Welcome to Practice Tips. My name is Cody Guarnieri from the law firm of Brown, Penderis & Scott, and my practice tip is on representing the victim in criminal court. First, is your client a victim? Connecticut General Statute Section 1-1K defines what constitutes a victim in Connecticut: an individual who suffers direct or threatened physical, emotional, or financial harm as a result of a crime, and includes immediate family members of a minor, incompetent individual, or homicide victim. Next, know your client's rights. The victims of crime in Connecticut are given rights both through the Connecticut Constitution and the Connecticut General Statutes. The Connecticut Constitution, Article 1st, Section 8, requires that a victim of crime be treated fairly and with respect throughout the judicial process, that the matter be timely disposed of, and that certain information and access be provided to the victim. The Connecticut General Statutes require that a victim be given notice of pretrial diversion, be able to attend hearings and give a statement before any disposition, and allows a victim to request in writing to be kept informed by the Office of the State's Attorney. Defendants who dispose of their case through pretrial diversion or seek to dispose of their case through pretrial diversion, including through accelerated rehabilitation, the supervised diversionary program, alcohol education, family violence, drug education, or addiction CADAC program, will be required to provide notice to any alleged victims of their offenses. And that notice will include the contact information for the Office of the State's Attorney and the date and the time at which the application will be heard by the court. A victim of a crime may also be contacted by the investigator from the Office of the State's Attorney. At the time of a hearing on a pretrial diversionary application, the victim will have the opportunity to address the court regarding whether they think the defendant should be admitted and any issues of restitution or the return of property. Post-conviction, victims also have the right to present a statement to the Board of Pardons and Paroles before a convicted person is eligible or able to get parole. A victim is allowed to be notified of any violations of probation by the offender, and can seek through the criminal court at the time of disposition or later through a civil court a continuing order of protection. In representing a victim of a crime in Connecticut criminal courts, the attorney should consider the client's goals and consider the reasonableness between the nature of the victimization and the crimes charged. Is the area of redress that you're seeking within the purview of the criminal court, or is it better left to some other civil or administrative venue? Also consider points of access. The attorney should submit an appearance and a letter of representation to the Office of the State's Attorney and should also be heard on the record before the court. The attorney should also consider whether, under the circumstances, they should contact somebody from the Family Relations Office or the Office of the Victim's Advocate. Thank you for watching Practice Tips.